And maintaining the park in a nice condition may not be compelling. If it's time, place, and manner restriction, the government has to show only that it's a significant government interest, not as important as compelling. And Justice Marshall said, well, I admit that it's a significant interest, but the government has, and the majority haven't adequately explained how prohibiting the demonstration activity will substantially further that interest. Well, if the interest is keeping the parks tidy and available for all kinds of users, isn't it obvious that filling up the parks with tents and people living in them interferes with that interest? I don't know, maybe I'm missing something. Yeah.
So with their Symbolic city, were they not allowed to have tents? Because they already received the permit.
Yeah, the Park Service was, I was quite surprised that the Park Service was willing to let them put up their tents and let the tents sit there.
So if they're allowed to have a permit to have their Symbolic city protest during the day and even to have like a day and night vigil, then I don't understand how sleeping, like the act of sleeping, which is what people do when they're outside, and that spare space is going to make situations worse in like the maintenance of the park.
Yeah. Yeah, I agree. It's baffling that sleeping was the trigger that set off the Park Service and the court. It was the act of sleeping that was what interfered with the significant government interest. Robert?
I think that is focusing on the act of sleeping as symbolic speech kind of emphasizes the point that the regulation he discusses it as
Was not unconstitutional.
no, it was not content.
Oh, content neutral.
He discusses it as the court's not showing the significant public interest in keeping the people sleeping there.
Yeah.
And I think opposing that to there's going to be the tents and people there anyway.
Mhm.
With the permit.
Mhm.
So yeah, I believe you think that you find that it's not because the act of sleeping is necessarily I think part of the whole idea.
Yeah, hang on a second, Mark. There might be, all you media studies people, they still study McLuhan and any of these, Marshall McLuhan? The medium is the message, right? Well, the medium here is sleeping, isn't it? I mean, that is the message. Mark?
Thanks for the question. If they have all these permits, they somehow got transmessed with caffeine. They stayed awake for like weeks at a time. They still got into, they still had this issue. Getting thrown out. They didn't actually just sleep. They stayed awake. Just occupied park.
Where does that take you?
So like, if sleeping was the issue here, well, they still had to go. They still had all these issues. They go to the courts, getting thrown out and not. If they just stayed awake,
Right, but then it wouldn't be communicating a message that that they meant to get across to everybody.
You still communicate, they know where to go, so long as you're held together and show.
Dina?
I guess if you wanted to play devil's advocate, you could say, what's the difference between staying overnight and having a day and night vigil? You still have someone there 24 hours a day.
Yeah. So where does that take you? That the government's restriction is invalid, inappropriate.
Is an appropriate manner restriction.
Oh.
They're still allowing people to stay overnight. They're just not allowing people to sleep. Is one of the things.
Yeah, but if the government's interest in maintaining the park's appearance and all that is valid, then why are they allowing people to stay there overnight, awake or asleep? Sophie?
I think the two ideas are almost like inherently contradictory because the demonstration is trying to say like we are living here and like part of establishing that like ideal of living is sleeping, and whereas the regulation in place to disallow sleeping in parks is intended because when you're sleeping somewhere it's as though you're making like a home there and you're less nomadic if you're sleeping. So they're both trying to use sleeping to convey the same idea, but in one case the government and the National Park Service is taking it the negative and the reason not to allow sleeping is for the same reason that this demonstration will not allow.
Mm-hmm. Well, makes my head swim to try to figure this out. Justice Marshall's footnote at the end of the excerpt in the Reader is prophetic and makes the point, came out earlier, about these are poor people and their alternative channels of communication are limited by their poverty, and you can't pick on a mode of communication that is available to poor people and outlaw it without outlawing the message. A disquieting feature about the disposition of this case is that it lends credence to the charge that the First Amendment, in conjunction with a social order marked by large disparities in wealth and other sources of power, tends systematically to discriminate against efforts by the relatively disadvantaged to convey their political ideas. That sounds pretty current. No?
So does that mean that part of the holding of the space is that you're not entitled to the most effective means of communication? I guess that you missed this week because like Justice Marshall says, like synthetic speech and really delve into the circumstances around it. Does that leave us anywhere with most effective manner or effectively lost manner?
Well, the court did not say anything about most effective manner. That was my question, really, to know, are you entitled constitutionally to the most effective manner of expressing your message? And you're not, because of the effect of time, place, and manner restrictions. If the court upholds a time, place, and manner restriction, that's on your chosen mode of communication, which you decide is the most effective, given your resources and what you want to say, where you want to say it. But if the government has a valid time, place, and manner restriction on it, you're not entitled constitutionally to the most effective way to get your story across. Have you? Is that you? I thought your name was...
No, my name is
Oh, sorry. I had you mixed up. Speak. Get your message across as effectively as you can in the time and place and manner that you...
I think in like even the very like beginning, like the first paragraph states that issue is basically prohibiting like whether or not prohibiting demonstrators from sleeping is like constitutional. And I think that they didn't especially like prohibit them from staying in that park. They even or the Park Service like gave them a permit in which they could direct like symbolic tents. And I think that's not like I think that the restriction is content neutral because like I don't think most effective mode of communication is guaranteed by the Constitution. And I feel like because they allowed those demonstrators to be there, just not sleep there. I think that it was content neutral. I mean, I think like for example, Safeway is open at 24 hours. It sounds like they are, but I feel like someone like sleeping in a Safeway like all day and night versus like walking around and just like aimlessly wandering the aisles. Like I don't think sleeping is like the same as like wandering aimlessly for 24 hours. And like the Safeway, like that's kind of the same like image. I don't think they expressively like stated the difference between like sleeping in a place versus like just occupying that space as like a demonstration of like the slave
Mhm. The Safeway situation is different, you realize, because it's private property and they can exclude people that are not there to do business with them, whereas the public parks, the mall in Washington, is the quintessential public forum, the meeting place for the citizens to get together and speak and discuss ideas and have demonstrations and so on. Sounds like you were agreeing with the outcome of the Clark decision, right? There's been a complete turnover on the court since 1984, entirely different justices. You have a prediction of how the current court would come out on the facts of this case?
I still don't know how I feel about it.
I don't either.
I think it was still hold, because, I mean, it's not like, because the whole thing was it said, we talked about, it wasn't just sleeping solo camp. Because I did like the idea about taking the caffeine and just staying up all night, but then like it says here that it's storing personal belongings, making fires, digging cooking, like all that goes into no camping on those sites. So I don't think it was pinpoint, you just can't sleep here. It was more like, these are the rules, period. We're going to give you accommodation, you can leave your tent here. And that was like kind of bending what they originally first said, that it said personal belongings was prohibited. So they were bending a little bit. And so I don't necessarily think that it's, I definitely think that.
Mm-hmm. Yeah.
I mean, maybe I'm just watching, but I don't even
Me too. Huh?
because before they even protested in the rules, it says no sleeping in the lodger. It doesn't say no sleeping in the lodger if you're against the government. And I think that they're being very accommodating and saying you can't leave tents here even though it is an eyesore and people can go there every day and visit Washington. And I think it would have been a much different outcome if like 2 days after the protest, they added that rule, which is what happened in New York with the Occupy movement. So I think I feel really
Okay, well, let's get closer to the Occupy. If the same facts came up as in the Clark case and the homeless case, today, to a different court, entirely different court, 9 different justices, how would they decide? Well, the first thing they would do was decide whether stare decisis will be followed, right? I mean, there's the precedent of Clark staring them in the face. And if the facts are no different, what's the justification for departing from what has already been decided in the Clark case? The fact that it's new people who become the deciders does not justify junking the stare decisis rule. Then look at a twist on the time, place, and manner regulation in a case that is currently still in the courts, the day laborers case that was decided by the Ninth Circuit Court of Appeals sitting in San Francisco last September. The decision of the Ninth Circuit was an en banc decision, which means that it was not the normal 3-judge panel of the court, but it was a panel of 11 judges of the court sitting en banc because enough judges on the court thought that the initial 3-judge decision needed to be reconsidered. And so they assembled a panel of 11 judges of the court to sit en banc and settle the law for the Ninth Circuit. And the case involved, the Juanaderos decision involved an ordinance, a law of the city of Redondo Beach that they called an anti-solicitation ordinance that bars anyone from standing on a street or highway and soliciting or attempting to solicit employment, business, or contributions from an occupant of any motor vehicle. And the Ninth Circuit Court of Appeals held that ordinance was a violation of the First Amendment on its face. And the reason that the court decided that it was invalid was because it was not a proper time, place, and manner restriction of the speech. And the court did some curious things. It decided, this is not curious, but it's interesting, that solicitation constitutes protected expression under the First Amendment. Asking for business, sort of a commercial proposition, is protected speech. There's a whole bunch of cases that the Supreme Court has decided about commercial speech that we're not going to get into. And the court has wobbled on this. It used to be that commercial speech was unprotected. If it was merely proposing a business transaction, that was not considered protected. The court changed so that, for example, advertising, you can't forbid businesses from advertising their wares. And the current conservative majority of the court is somewhat favorably inclined toward protecting commercial speech as much as political speech. But the court in the day laborers case doesn't address whether this is commercial speech and therefore has more limited protection. They simply say it's protected expression. And it's protected expression in this case because it occurs in one of those quintessential public forums, the streets, where people go to speak their minds and so on. And then says, well, what's the test for deciding whether the ordinance here is constitutional? It's the time, place, and manner rules established in the Clark case, citing the Clark case, the homeless case. And then the court goes on to assume that the ordinance here is content neutral and therefore satisfies that prong, that factor of the time, place, and manner formula. Says this was content neutral. Is it? Tina? What if it only bans some solicitation? What difference does it make that it bars all solicitation? I mean, isn't it worse if it singles out political solicitation than solicitation, hire me so I can go to work today?
So by barring any instance of that, it's still saying that based on the content, based on the fact that you are asking for something, whatever it is, you are basically censoring that message based on what it's asking for.
Yeah, and doesn't that sound like it's content-based? It does to me too. I mean, they're not. They haven't outlawed singing on the streets, and they haven't outlawed political electioneering, holding up signs, vote for Joe Smith for sheriff. They haven't done that at all. They've targeted this ordinance at solicitation of employment. And that seems to me to be content-based. I don't know why the court didn't analyze the ordinance that way. John?
That's conduct, though. I mean, that,
Conduct.
yeah, if you're trying to
Solicitation?
Yeah, to get for work. I mean, how's it?
Please hire me. Is that conduct?
I mean, it's not. You're not. You want a job, but that's not actually you want to. You want to work. It's not like you're expressing. You're expressing the fact you want to work, but you're not. It's not like. I'm not expressing speech.
I've been homeless for 6 months. My family is starving. I really need a job. Would you please hire me for the minimum wage for today? That's not speech?
See what you put down there. You know,
Yeah. I mean, you can disagree with the court on several of the factors, one of which, they say, solicitation is protected expression. It's characteristically intertwined with informative and perhaps persuasive speech, seeking support for particular causes on economic, political, or social issues. You can solicit people for various things. But political solicitation was not covered by this ordinance. And they targeted economic solicitation as what they wanted to outlaw, because they were aiming at the day laborers. That was their problem. Well, it seems to me that it's content-based to that extent. Maybe I'm wrong, but if it were content-based, then it's a much simpler case for the court to decide, because that triggers, you're going to get etched into your hard drive forever. That triggers strict scrutiny, meaning the government's got to show compelling interest and narrow tailoring to serve that interest, which is basically the kiss of death for government regulation of speech. Virtually never does the court uphold a government restriction on speech when it applies strict scrutiny. Okay, well, this court is being kind to the city of Redondo Beach by not applying strict scrutiny, and instead applies the three factors of Clark about time, place, and manner. And what's the government's significant interest here in the Redondo Beach case? Yeah. Mr. Rodriguez. Yeah, traffic safety and traffic flow, too. I think they're entitled to prevent disruptions of the flow of traffic and obstructions to the flow of traffic. They're entitled to deal with that. That's a significant government interest. And the court says it's outlawing solicitation is not content-related. So you've got one factor, at least, of the time, place, and manner rules is satisfied. What about the alternative means of communication of the day laborer's message? The court really doesn't address that, yeah. There are? Like what? Yeah, that's Judge Kosinski's dissent. You get enraptured by these dissents. That's his dissent. Panda Express can't decide that it's going to stick a stand out on the street and sell mushu pork to passing motorists. And everybody would agree that they shouldn't be able to do that. They have to get a business license and they have to stay within the confines of their store, if that's what the ordinance provides. And nobody's going to say that that denies Panda Express its First Amendment right of free speech. Yeah. Mm-hmm. That's the factor that those examples relate to, right? The reasoning being that it's not narrowly tailored if it sweeps within its prohibition all kinds of perfectly innocuous activities like Girl Scouts selling cookies, students yelling car wash, and so on. Right?
In regards to alternative channels, I think the goal of the day laborers is to reach specific people, and those people are in their cars, either going to or from place or going to help. And their alternative channels for like Craigslist, where they're distributing people at home, circuit web, or maybe not necessarily paying for traffic services.
Mm-hmm. Yeah. Well, they have to be, no, they can't be on their own property. They have to be in the street. But that can be on the sidewalk, I take it. The ordinance is not perfectly clear. It says standing on a street or highway. And if you're standing at the curb, I think, and trying to flag down drivers, that's what it's meant to cover. Why would that be different? Well, yes, if they're in fact if they're on their lawn with their lemonade stand, they're not within the ordinance. They've got to be on the street. They've got to be on public property that the government has a right to regulate the use of, including the street.